5 seconds to go. Start. From a reading of the above said rule, it is clear that to pass an order as disciplinary measure by adopting special procedure in certain cases, Rule 161 itself mandates recording of reasons. The normal rule for conducting an inquiry is governed by Rules 132, 148 and 153 of the RPF Rules. If the authorities invoke special procedure unless they record reasons as contemplated in the rule itself, no order could have been passed by invoking Rule 161. At no point of time, appellants have produced file to show that any reasons are recorded in such file also. It is a settled legal position that when rules contemplate method and manner to adopt special procedure, it is mandatory on the part of the authorities to exercise such power by adhering to the rule strictly. Dismissal of a regular member of force is a drastic measure. Rule 161, which prescribes dispensing with an inquiry and to pass order against a member of force, cannot be invoked in a routine and mechanical manner unless there are compelling and valid reasons. The dismissal order dated 22nd October 1998 does not indicate any reason for dispensing with inquiry except stating that the respondent had colluded with the other head constable for theft of non-judicial stamp papers. By merely repeating the language of the rule in the order of dismissal will not make the order valid one unless valid and sufficient reasons are recorded to dispense with the inquiry. When the rule mandates recording of reasons, the very order should disclose the reasons for dispensing with the inquiry. The argument of learned senior counsel for the appellants that if file contains reasons, same is sufficient to maintain the order deserves rejection. When inquiry is not conducted, member of the force is entitled to know the reasons for dispensing with inquiry before passing any order as a disciplinary measure. The respondent was only a head constable during the relevant point of time and he was not in powerful position so as to say that he would have influenced or threatened the witnesses had the inquiry was conducted. The very fact that they have conducted confidential inquiry falsifies the stand of the appellants that it was not reasonably practicable to hold an inquiry. The words not reasonably practicable as used in the rule are to be understood in a manner that in a given situation ordinary and prudent man should come to conclusion that in such circumstances it is not practicable. In the present case, there appears no valid reason to dispense with inquiry and to invoke Rule 161 of the rules. We are in agreement with the view taken by the High Court. In the case of Singh and others versus Union of India and others, this court has held that in the facts and circumstances of the said case, it was not reasonably practicable to hold a fair inquiry. As such, it was held to be justifiable on the facts of the case, whether it is practicable or not to hold an inquiry is a matter to be considered with reference to the facts of each case and nature of charge, etc. In the judgment, in the case of Tarsem Singh versus State of Punjab and others, this court has categorically held that when the authority is of the opinion that it is not reasonably practicable to hold inquiry, such finding shall be recorded on the subjective satisfaction by the authority, and same must be based on the objective criteria. In the aforesaid case, it is further held that reasons for dispensing with the inquiry must be supported by material. With regard to plea of the appellants for grant of back wages in the case of Tarsem Singh, this court has held that payment of back wages would depend on result of the inquiry. In the present case on hand, by the time the order came to be passed by the learned single judge, the respondent had retired from service on attaining the age of superannuation. In normal course, we would have permitted to hold inquiry, but keeping in mind that the respondent had retired from service even before the judgment was rendered by the learned single judge, we are not inclined to do so at this stage. Stop.